Okay, let's begin section 2 of this program. And in this section of the program, I want to review with you some ideas that are going to have tremendous impact on your QME practice. And I'm going to be talking primarily in this section about the QME examination as it relates to the non-physical examination component of your face-to-face evaluation with the injured worker. So we're going to be talking about your interview techniques. We're going to be talking about your observation of the injured worker. And I want to establish the philosophy of this section. Part of the technique of the QME examination and some of the secrets that are used by the very best evaluators in the entire industry has to do with their communication skills in the face-to-face evaluation with the injured worker. And so I want to go over several different ideas for you as relates to creating a comfortable atmosphere with the examinee so that the examinee is comfortable with you and so that the examinee is open and honest and communicating with you in a way that allows you really to get to the bottom line of their condition. It allows you to arrive at a conclusion as to their true and accurate condition on the day of your evaluation of them. So to establish the general philosophy of this section, I want to review with you Labor Code 3202 and what's known as the Liberal Construction Code. Okay, so I don't know how many of you have the Workers' Compensation Laws book of 2015, but you can look up this code section. You can simply Google it by putting it in your search bar, and it'll come right up. And I want to read this code to you word for word as it's described in the Labor Code. And this is known as the Liberal Construction Code, and this code is basically going to establish our philosophy and the tone of our face-to-face meeting with the injured worker. So we'll spend a little bit of time here talking about liberal construction. Okay, so let's read straight from Labor Code 3202. It says that this division, and when it says this division, what it means is that Labor Code 3202 is the first, no, it's not the first. Division 4 begins with Labor Code 3201, I believe, either 3200 or 3201. So 3202 is at the very beginning of what's known as Division 4 of the Labor Code. So it begins by saying that this division, meaning Division 4, and Division 5, which commences with Labor Code Section 6300. So let's just pause there. That's a lot of labor codes between 3200 and 6300. And Division 5 only begins with Section 6300. It contains many labor codes beyond that, all the way up to Labor Code 7997. So that's a lot of labor codes. From 3200 to 7997. So what it says is that this division, Division 4 and Division 5, shall be liberally construed by the courts. And I've highlighted the term here, by the courts. By the courts. We are not the courts. We are the qualified medical evaluators. But I'm going to relate our construction, our liberal construction, of our job to the liberal construction by the courts as we develop this principle. So it says these codes, all of these codes from 3200 all the way to 7997 shall be liberally construed by the courts with the purpose of extending their benefits for the protection of persons injured in the course of their employment. So let's review some of these divisions and some of these codes. Now, you may be familiar with some of these divisions and some of these codes. Division 4 includes labor codes all the way from 3200 to 6002. and this deals with workers' compensation and insurance. Division 5 includes labor codes 6300 all the way to 7997, and this division deals with safety in employment. So let's review some of these codes that you might be familiar with. Some of the codes that you might be familiar with include, for example, Labor Code 3600. 3600, the conditions of compensation liability, which deals with the presence or absence of industrial injury. Those code sections are subject to liberal construction. Chapter 7, all of the labor codes that we described in Section 1 of this program, including 4060, 4061, 4062, which govern the QME panel process, all of those are subject to the liberal construction of the labor codes. Part 2, the computation of compensation is subject to liberal construction. And basically, all of the labor codes from 3200 to almost 8000, Labor Code 8000, are subject to what is referred to as liberal construction. And liberal construction, simply by definition, states that all of these codes shall be liberally construed with the purpose of extending benefits for the protection of persons injured in the course of their employment. So what does that have to do with us as qualified medical evaluators? Well, the liberal construction philosophy establishes the tone of our qualified medical evaluation. And I've discussed this with several authorities, and I've received mixed reviews on this discussion. In discussing this philosophy with attorneys, some attorneys believe that this philosophy exactly applies and that the liberal construction philosophy applies to the qualified medical evaluation. Other attorneys have told me that the philosophy of liberal construction is applied by the courts and is applied by the judges and is not applied by the qualified medical evaluator. But everyone that I have spoken to and discussed this concept and this idea with has agreed that the liberal construction is generally applicable to the qualified medical evaluation, if not exactly applicable to the qualified medical evaluation. And so I present this here to you simply as an idea and simply as a philosophy which I believe would be upheld should it ever be challenged. I can't say that with absolute authority, but I have given you some of the background as to the genesis of this idea. And I'll read a couple of citations from notable authority in just a moment to help support this idea. So what this means for us as qualified medical evaluators is that when we approach our very next QME examination, we approach the examinee and the entire evaluation process with an attitude of liberal construction. In other words, that any gray areas, any questions of doubt, any unresolved issues, in general, should be resolved in favor of the injured worker, unless there is good cause to opine differently. Let me say that again. Anytime there is a tie at first base, in baseball, the tie goes to the runner. Well, in workers' compensation, the tie goes to the injured worker. It's called liberal construction. All issues of doubt, all gray areas, all stumbling blocks are handled through the application of liberal construction. In workers' compensation, the tie goes to the runner. And when we meet with our injured worker, there are going to be circumstances where issues are not cut and dry. Issues are not black and white. There are shades of gray, and there are areas that are not simply hardcore fact. Many times we have to exercise what we refer to as reasonable medical probability. And in these times, we resolve these disputes, we resolve these gray areas, we decide with reasonable medical probability in favor of providing benefits to the injured worker. It's referred to as the liberal construction code. So in establishing the philosophy of this section of the program, where we're going to begin talking about the face-to-face evaluation with the injured worker, I want you to go into your next evaluation with an injured worker with an attitude of liberal construction, with an attitude that the purpose of this evaluation is to provide benefits to the injured worker. I had one applicant attorney explain this to me by telling me, he said, Perry, he said, workers' compensation is a benefit delivery system. It's a system that's set up to deliver benefits to those who have been injured in the course of their employment. So when you go into your next QME evaluation, you approach the injured worker with an attitude of liberal construction. And let me tell you, examinees can tell a lot about you by your attitude. And they can tell whether or not you have an attitude that's for them versus an attitude that is against them. And I'm asking you to adopt an attitude that is toward them, that is an attitude of liberal construction, that unless there is good cause, unless there is evidence to the contrary, gray areas and disputes, whenever possible, are to be resolved in favor of the injured worker. Now, as I said earlier, there are some authorities who say that the doctors are not under the onus of liberal construction. Rather, it's the courts that are under the onus of liberal construction. But I've had others who tell me that indeed liberal construction also applies to the QME panel process, because all of the labor codes encompassed within the QME panel process are within Divisions 4 and Divisions 5, all of which are subject to liberal construction. So I want to review some citations for you from a notable authority and help shed a little bit more light on this idea of liberal construction. And you may draw your own conclusions about this topic for yourself. Okay, and what I want to read for you here are some citations from a notable writer and blogger on workers' compensation issues. And I just want to review what he says and what he provides in terms of references, in terms of case law, as to how workers' compensation disputes are handled under the Labor Code 3202, the liberal construction code. So I just want to read a few passages that are relevant to our discussion here. So those of you that have the PowerPoint presentation can follow along with me. Those of you that do not have the PowerPoint presentation, I've included these references in your course materials. Okay, so let's begin. It says here, and this is according to this notable authority, he says Labor Code 3202, the Liberal Construction Code, does not refer to the entirety of the Labor Code or even to all the parts of it that pertain to workers' compensation. By its own terms, Labor Code 3202 specifically applies only to Division 4 and Division 5 of the Labor Code, and we talked about that. It says that Labor Code 3202 omits Division 1, which contains many workers' compensation statutes, including claims for discrimination. Nevertheless, it, meaning that the courts, nevertheless, it has been explicitly held that the liberal construction rule is not limited to Division 4 and Division 5 of the Labor Code. And then he cites some case law. He says, in Judson Steel Corporation versus the Workers' Compensation Appeals Board, the Supreme Court held that the rule of liberal construction under Labor Code 3202 applied to claims under Labor Code 132.A. Furthermore, in Webb versus WCAB, the Supreme Court found that Labor Code 139.5, which is a vocational rehabilitation statute, was subject to the liberal construction rule. In both cases, the court explicitly stated that, and this is a quote, the rule of liberal construction applies to all aspects of workers' compensation law, unquote. Now, emphasis is provided here that the code, or Labor Code 3202, applies to all aspects of workers' compensation law. It does not apply to all aspects of the QME examination. However, the philosophy that I'm forwarding in this portion of the program is that for our purposes, we want to adopt an attitude. It's just an attitude and a philosophy of workers' compensation, of the qualified medical evaluation. However, this philosophy and this attitude has good basis in case law. Further, let's continue. It says, as a result, courts have applied the rule of liberal construction to resolve a wide variety of procedural and substantive questions affecting the availability and adequacy of compensation in favor of injured employees and other applicants. Now, I want to read a few other citations from this blog so that we can provide some color to Labor Code 3202 and show some upsides and downsides and some applications and some areas where it's not applicable. But in the end, we're going to summarize it by simply stating that the liberal construction philosophy does apply to the qualified medical evaluation. Okay, so let's talk about the application of Labor Code 3202 to questions of fact. Questions of fact. He states here that the rule of liberal construction would arguably apply only to the interpretation of laws, that is, what the statutes mean, and not to questions of fact, that is, what the applicant needs to do in order to prove his or her case. The courts have stated that Labor Code 3202 was enacted to provide that all parties, including injured workers, must meet the evidentiary burden of proof on all issues by a preponderance of the evidence. So liberal construction under Labor Code 3202 may no longer apply to questions of fact. So in other words, if an injured worker actually did not injure themselves at work, in other words, the facts do not support an industrial injury, then Labor Code 3202 does not apply. However, Labor Code 3202 does apply to the interpretation of the laws and the labor codes governing the workers' compensation process, but it does not simply provide for industrial injuries when actually there were no industrial injuries on a factual basis. Okay, let's continue with other important citations. Several cases failed to find that applicants sustained industrial injuries when the injured workers failed to prove their claims by a preponderance of the evidence. So the facts still need to support the presence or absence of an industrial injury, and we don't simply opine for an industrial injury just to provide the examinee with benefits under workers' compensation. However, the philosophy of liberal construction is going to be something that we apply in those cases where the industrial injury has already been accepted, and now the examinee has come to the qualified medical evaluation. In Power versus the Workers' Compensation Appeal Board, the court rejected an argument that whenever there is a conflict in the evidence, the principle of liberal construction must result in a finding in favor of the employee, irrespective of whether the evidence against him has more convincing force and the greater probability of the truth. So when the evidence does not point towards an industrial injury or does not point toward the favor of the injured worker, that does not mean that we opine for the injured worker. In those cases where the facts are clearly against the injured worker, or the facts clearly do not support the statements or the claims of the injured worker, we are not obligated to opine in favor of the injured worker. Okay, so let's see if we have any additional important points here. It says that Labor Code 3202 does not appear that any courts have applied Labor Code 3202 to determine close issues of fact in favor of the injured applicant. Instead, one decision recognized that both Labor Code 3202 and the Ware case require that there be a preponderance of evidence that a person's work contributed to his or her injury. So you may have heard the liberal construction code inappropriately applied, that in all cases decisions are rendered in favor of the injured worker when there is factual evidence to the contrary. That's not the philosophy of Labor Code 3202. So for our purposes as the qualified medical evaluator, we're seeing injured workers presenting to us who have already had their industrial injuries accepted, at least for the most part. There are those cases that we see that are Labor Code 4060 cases, over cases that we're seeing for the determination of compensability. But for the most part, we're seeing examinees who have had their injuries already accepted. And so for our purposes as the qualified medical evaluator, the liberal construction philosophy means that we simply give the examinee the benefit of the doubt in those areas where there's a gray area, in those areas where decisions are not simply black and white, where there are alternate possibilities. We simply, whenever possible, adopt an attitude that favors the examinee. And I want to give a couple of examples to illustrate this before we then proceed with some of the topics in this section. And I want to tell you a story to help illustrate this point and this idea of liberal construction. And I want to preface this story by just giving you a couple of quotes, one of which is by Mark Twain. Mark Twain said that most people are just about as happy as they make up their minds to be. And what he meant by that is you can be happy or you can be sad, and you can decide yourself as to how happy you want to be. It's an internal decision. Well, what does that have to do with us as qualified medical evaluators? Well, what it has to do with us is that we have the choice as qualified medical evaluators. We have the choice, and we have the privilege to make up our minds as to how we're going to see our examinee. We can see our examinee with an attitude of liberal construction, with an attitude of caringness and kindness and resolving issues in their favor, or we can decide to be contrary and be adverse to our injured workers. And when I'm asking you, in accordance with Labor Code 3202, to see your examinee in a light and with an attitude of liberal construction. Another example, another appropriate quote, is that you've heard it said that beauty is in the eye of the beholder. What you see is what you want to see. You can see beauty or you can see ugliness in your examinee. And you can see a bona fide examinee or you can see a symptom magnifier or malingerer based on how you make up your mind. And I'm asking you to make up your mind in advance to adopt an attitude of liberal construction, that resolves gray areas, and resolves difficult disputes whenever possible in favor of the injured worker. It's an attitude that we apply to our general philosophy of the qualified medical evaluation. And I want to tell you a story to help illustrate this point. And this is a story that was told to me by an applicant attorney when I was explaining to him some difficulties and some challenges that I was facing in evaluating injured workers. And he told me this story, and I believe it applies exactly to our evaluation of injured workers. And it's a story of 3 umpires. And maybe you've heard this story, but I'm going to repeat it here anyway to illustrate this concept. So this applicant attorney, he said to me, he said, "Perry, have you ever heard the story of the 3 umpires?" And I said, "No, tell me the story." He said, "Okay. Well, there was these 3 umpires. And one day a newspaper reporter went up to the 3 umpires and he said, let me ask you guys a question. How do you make your calls? How do you know when it's a ball or a strike? Or how do you know when the guy is safe or out at first base? How do you make your calls?" And the first umpire said, "I calls them as I sees them." And the second umpire said, "I call it like it is." And the third umpire said, "It ain't nothing until I call it." It ain't nothing until I call it. And similarly, with our qualified medical evaluations, we have the authority to make the call. We can call the injured worker safe. We can call them out. We can call their claims strikes, or we can call their claims balls. We have the authority to make the call. It's not simply as it is. It's not simply as you see it. Sometimes we simply make the call. We make the call based upon our clinical judgment. We make the call based upon reasonable medical probability. And I'm asking you, in those times when it's incumbent upon you to make the call, that you apply the liberal construction code consistent with the philosophy of the entire code itself as it applies to thousands and thousands of labor codes in Divisions 4 and Divisions 5. Okay? So that's our philosophy to establish the tone of this section of this program. Let's move on now with some non-physical examination procedures in the face-to-face evaluation. And I want you to keep this code of liberal construction in the back of your mind as we apply it to many of the topics that follow in this section of the program.